2000 2010 reveals that we can find gays and lesbians everywhere in the United States. However, when we look at the places where they concentrate, we found out that they reside in a limited, although growing, number of large urban areas, and within them, they're concentrated in certain neighborhoods. Now, interestingly, the states in which gays and lesbians are present are not necessarily the progressive states. It's not the states where you can see the pro-gay laws. For example, Florida and Georgia attracts gays and lesbians, even though they're quite conservative. So something else is going on here. And what I will try to convince you is that the regulation of sexuality was decentralized. Despite the high-profile cases and legislation at the federal and state levels, in fact, most of the management of the issues pertaining to sexuality is taking place in cities. And we call the phenomenon, oh, that's nice, the localization of sexuality.
It should be working now.
What? Okay. Okay, no apparent connection between the state's attitude and the residential patterns of gays. So something else is going on here, and what's going on here is this is the map of the concentration of gays and lesbians. As you can see here, in the 5 most populated states, we have 2 that are not quite conservative, Florida and Georgia, and we can go, as we go down, we can see more of this. So, local governments have become the engine of legal development and innovation in the actually since the advent of the gay rights struggle, and they are still at the forefront to this day. The localization of sexuality was enabled by a 3-pronged legal structure. First, the lack of comprehensive federal legal protection of gays and lesbians. Second, the limited and bifurcated legal protection which states extended to them. And third, the traditional power of cities which enable them to deal with matters that are important to gays and lesbians. In other words, this legal structure was not a result of a well-thought-of processes. On the contrary, it has taken place almost haphazardly through an amalgamation of federal doctrines and inactions, state legislation and failures to act, and local initiatives and oversight. So one important caveat that I want to make before I continue is that we do not argue that law is the only factor that influenced gay and lesbian residential patterns. Clearly, historical, social, and economic factors play an important role as well. Our claim is much more modest, that the law plays a role, and more importantly, that the role that they play has been hitherto neglected, and there are some policy implications, normative implications, that we can draw from this. So the first building block of the localization of sexuality is the fact that the Supreme Court has never granted gays and lesbians the status of federally protected groups under the Equal Protection Clause. Romer v. Evans, which is rightfully considered a major advancement in the protection given to gays and lesbians, established a very narrow constitutional safeguard against discrimination. Although Romer invalidated Colorado's constitutional amendment that prohibited all levels of government from adopting pro-gay anti-discrimination legislation, it did so only since it found that the amendment was founded on animus towards gays and lesbians, thus failing the rational basis test. The court did not, however, grant gays and lesbians the status of a protected group, depriving them of the heightened protection given to racial and other discrete and insular minorities. The other protection granted to gays and lesbians, through the rights of privacy and liberty, has also proved to be very limited. As pointed out by many scholars, Lawrence v. Texas, as you may know, is the case in which the Supreme Court invalidated Texas sodomy laws, invalidated all sodomy laws for that matter, limited the constitutional protection to instances of intimate association, thus leaving gays and lesbians exposed to discrimination by states and local government in every place save by their private homes. In addition, the regulation of sexuality is localized by the absence of a broad and inclusive federal anti-discrimination laws protecting gays and lesbians. Title 8 and Title 7 both do not designate sexual orientation as prohibited ground for discrimination. An attempt to amend Title 7 was encountered failure every time it reached Congress. Also, attempts to enact a separate anti-discrimination law that would protect gays and lesbians, such as the Employment Non-Discrimination Act, ENDA, have also met fierce opposition and failed each time. Furthermore, the Defense of Marriage Act, DOMA, prevents the federal government from recognizing the validity of same-sex marriages performed by a state and exempts other states from their constitutional obligation under the full faith and credit clause to honor such marriages. Now, as you know, there are some high-profile legislative initiative changes that the Obama administration managed to pass. One is the Don't Ask, Don't Tell policy of the military was abolished, and Congress enacted the Matthew Shepard Act, expanding federal hate crime law to include sexual orientation. But these two are but a drop in the bucket, and they do not change the fact that the protection given to gays and lesbians at the federal level is minimal at best. Now, moving on to the state level, given the broad power of states, especially under the current revival of states' rights, and in light of the near absence of the federal protection, states are rather free to determine the degree of protection given to sexual minorities within their jurisdiction, and states were much more active than the federal government in doing so, both favorably and unfavorably. So, on the constitutional front, we have 4 state Supreme Court that prohibited their state from excluding same-sex couples from the institution of marriage. So, saying to the state, you actually have to allow a same-sex marriage. But 30 states amended the Constitution to actually ban same-sex marriage, including liberal and liberal-leaning states such as Oregon, Michigan, Wisconsin, and of course California. That recently a circuit court decided that the Prop 8 is not valid, but the Supreme Court, I'm sure, will correct it when it arrives. Other states, even some which have same-sex marriages and civil unions, such as North Carolina, Iowa, and Illinois, also contemplate amending the Constitution to ban same-sex marriage. And by the way, prior to Roe v. Evans, we saw a similar constitutional activism on the discrimination front. But because of Romer, now states cannot have constitutional bans on anti-discrimination that apply to all levels of government. Now, when we actually look at the legislative protection given to gays and lesbians, states fare much better. To date, 6 So we have 6 states, it's actually not 4, it's 6 states, the most recent of which is Washington. Today, the governor signed the bill, passed laws offering same-sex marriages. This is a nice picture of the states, but this is also civil union stuff. You have 21 states that have anti-discrimination laws that include sexual orientation as a prohibited ground. As you can see, we have repeat players here. We have 31 states that enacted hate crime laws that include sexual orientation. We have 17 states that have harassment and anti-bullying of students in schools, on the same-sex, homosexuals and lesbian students, and we have 18 states that have second parent adoption that include same-sex couples.
Question. There's also this civil union jazz.
Yeah,
Which, if I understand, anyway.
maybe at the end we can
Never
discuss
mind.
it.
Sorry.
It's okay. Yeah, it's true that we have some states that don't have same-sex marriages, but they have civil unions, and there are all sorts of other ways around it. But so compared to the federal level, states are much more active in regulating matters pertaining to sexual orientation. Yet, what I will want to convince you of is that when we compare this activity to local governments, states are fairly inactive in regulating sexuality. And what actually happens is that because states and the federal government are quite or silent or negative about it, what we see is a lot of action going on in the local level. Before I discuss what localities do and don't do, let me say a few words about the powers of local governments, because the extent of their activity is at least theoretically dictated by the power that they possess. So, when we look when you look in local government law, what you see is the localities vary dramatically in their powers and competences, depending, among other things, on the state in which they are located. States can delegate powers to local governments in two ways. One is Dillon rule, and the other is home rule. Under Dillon rule, city can do only what its states explicitly authorize it to do. Home rule generally allows local governments to act in a wide array of matters considered local in nature, but again, home rule itself has a lot of variety within it. So while in some states, localities enjoy fairly broad authorization, in most states, cities are given limited and enumerated powers, either because they're governed by the Dillon rule, or due to eternal limitation of their home rule authority. It is therefore quite surprising that despite this precarious legal status, cities have become de facto the focal point for the regulation of sexuality and a prominent site where such matters are disputed and adjudicated. Localities regularly address the most pertinent issue that matter to gays and lesbians, either favorably or unfavorably. So I will discuss some of these issues, among them recognition of same-sex partnerships, local anti-discrimination ordinance, enforcement of hate crime, zoning, land use, business licensing, public health, education, and districting. So there's a lot of ground to cover. When you're talking about same-sex partnerships, despite the famous rebellion of San Francisco against California, it is clear that issuing of marriage licenses to same-sex couples when the state do not recognize same-sex marriage is way beyond city power. But localities find ways to recognize same-sex relationships in creative ways. One such way is establishing local registries for same-sex couples. The cities that have established such registries are located in states, sometimes located in states, that have explicit ban on same-sex marriage. Some of these registries enumerate different rights and benefits which registered couples are entitled to receive, while other registries confer no formal and direct rights and benefits. Nevertheless, what happened is that private and public parties can make use of these registries in order to provide same-sex couples with various benefits, and they do that very often. These municipal actions have reached courts throughout the nation, and so far, both types of registries were upheld by state's court, holding that such registries are within our local matter, and because they saw a radical distinction between marriage and any other form of partnership. Thus, what we see is localization, the localization of sexuality at work. Lacking the power to confer on same-sex couples the full status of marriage, cities find innovative ways to use their power and to translate their views toward homosexuality into symbolic and material benefits. But if the impression is that most cities use their power in a manner favorable to gays and lesbians, in fact the reverse is true. The majority of local governments do not have domestic partnership registries, nor do they grant same-sex couples the same right given to married couples. Indeed, in the face of the growing number of states that legalize same-sex marriage, some local governments have become more hostile towards gays and lesbians, and conservative religious groups try to push for the adoption of what's called religious or conscience exemptions that would enable cities to exempt from marrying same-sex couples even in states that recognize same-sex marriage. So we see here a bifurcation between local governments that favor local government and do a lot of good stuff, and on the other hand, we see local governments that are doing the opposite. Another important way in which sexuality is localized is through the ability of local governments to adopt anti-discrimination laws. To date, according to a research that we have conducted, you can't see here anything, but this is the research, we're very proud of it. So over 640 cities and counties in which about 100 million Americans live have adopted some type of sexual orientation-based anti-discrimination law. Even more crucial is the fact that more than 1/3 of them reside in states that do not have sexual orientation-based anti-discrimination laws, and that their only protection is provided by local governments. These ordinances, often called civil rights ordinances, usually apply to employment, housing, and public accommodation, and what you can see, I won't read it, is the number of localities that prohibit discrimination in all three areas, in employment, in housing, in public accommodation. And there are some localities that prohibit discrimination in some particular services, such as, peculiarly, the provision of cable TV. Many localities have ordinances that prevent cable TV providers from discriminating against same-sex couples and gays and lesbians, which is very interesting. I think. Why would cable TV providers have a problem? Maybe it's the people that come and install that don't want to come. Anyway, one of the main problems with the localization of anti-discrimination is that American localities possess rather minimal enforcement mechanism of such ordinances. They're often limited in the sanctions available to them, in the fines they can impose, and in financial resources. Aware of these problems, cities seek new and creative ways to advance their vision towards homosexuality. What seem to be the frontier of legal development in this area are new types of ordinances called equal benefits and equal opportunity ordinances. And these novel types of regulation use the city's power to purchase and procure goods and services from private parties in order to induce them to adopt and implement sexual orientation-based anti-discrimination measures. So equal benefits ordinances require all firms who contract with the local government to offer equal benefits to their employees. Localities that adopt such policies are tying their own hands, so to speak, by prohibiting themselves from doing business with firms that fail to meet this standard. This measure, perhaps not surprisingly, was attacked by a state official. Recently, Tennessee Governor Bill Haslam, this is the guy, signed a bill prohibiting local municipalities from enacting anti-discrimination ordinances, forcing them to rely on state law. The bill directly followed a Nashville ordinance passed in April 2011, which barred the city from doing business with companies that do not adopt an equal opportunity policy towards gay and lesbians. While the city already had anti-discrimination protection for its own employees, the ordinance prohibited anti-discrimination against gays and lesbian workers by any private employer that contracts with the city. And this state legislation, although not yet challenged in court, demonstrates the fragility of local power. Indeed, in most cases, if a state wishes to overrule cities' decision on such matters, it can do so quite easily as long as it refrains from doing it through a constitutional ban, Romer style. So it's, again, very interesting that cities still manage to do that. So to sum up this discussion, cities' power to enact such ordinances produce a huge divergence among localities with regard to the degree of protection they grant gays and lesbians. Thus, while some cities have become safe havens for sexual minorities, other cities have left sexual minorities exposed to discrimination, both by the local government itself and by private actors. Another field in which local governments are really active is criminal law. And although criminal law is, as you may know, a state matter, local governments have significant powers in relation to it because the dominant enforcers of criminal offenses are local police forces. Therefore, cities can influence the safety of their gay and lesbian residents by investing resources on preventing, investigating, and prosecuting hate crimes. And in this respect, it matters it matters less whether the state have enacted a hate crime law that includes sexual orientation, since the city can utilize its state's regular criminal laws in order to protect gays and lesbians from hate-based violence. But local policing can also be used in ways that target and harm gays and lesbians, sometimes intentionally and sometimes unintentionally. Local police can crack down on gay men for cruising and for having sex in public, charging them with public lewdness, and they can raid gay saunas, gay bar, etc., such as Giuliani's anti-sex policy in New York. And although heterosexuals also are prohibited from doing all these things, in fact, it's much more common for the police to raid such gay establishments than heterosexual ones. Hence, such police actions, even if they result from a general anti-sex ideology, disparately impact gays and diminish their ability to use public space. The next thing is municipal police powers that are aimed at protecting the health, safety, morals, and welfare of the people, and have immense impact on the daily life of city residents. The way in which these powers are used make localities more or less attractive to gays and lesbians, and they can be used by local governments to reflect their attitude towards sexual minorities. Zoning and land use enable local governments to determine the physical appearance of the locality, the nature of the businesses that operate in it, who will be able to reside in it, and how its public space will be used. They do so by deciding, for example, whether only single-family homes can be built in the jurisdiction or whether apartment buildings can also be constructed, whether to allow only traditional families to occupy houses or whether unrelated couples can also share a house, whether to enable opening in adult businesses, restrict them, or prohibit them altogether. So what we see is many localities, usually suburbs and townships, that have zoning and land use ordinances that severely restrict, sometimes prevent, gay individuals and families from residing within them. Although these ordinances do not explicitly prohibit gays and lesbians from living in the locality, that would be unconstitutional, law that prevents unrelated individuals from sharing a household can seriously curtail the ability of gays and lesbians to reside in it in states that do not recognize same-sex marriage. Cities' zoning authorities have also had the effect of permitting, restricting, or excluding gay-related establishment, much like housing. This impact on gay venues sometimes occurring intentionally, sometimes unintentionally, resulting from the city's general policy regarding bars and clubs. But anyway, it's clear that the concentration of gay venues, bar, clubs, saunas, etc., like in cities like San Francisco and New York, would not have been possible without this city's explicit permission of such land uses. Hence, while in many large cities, gay bars are regularly permitted, in smaller cities and towns, zoning laws serve to restrict their operation. Cities' regulation of sexually oriented businesses within the jurisdiction is also achieved through other police powers, such as the duty to protect the public from health risks and public nuisances. Many American cities have local ordinances prohibiting establishments that are deemed to be a public health nuisance, and in many cases, these ordinances constrain the discretion of local public health officers by defining sex businesses as creating public health nuisance per se. The development which followed the AIDS epidemic in the 80s and Mayor Giuliani's cleanup policies in the 90s, for instance, demonstrate the ways in which city can use such power to regulate sexuality or sexually oriented businesses. And to date, gay saunas, bathhouses, bookstores, theaters, bars, etc., are regulated through the combination of zoning law, public health code, and nuisance law, all enacted and enforced by local governments. Public schools are operated, funded, and governed by local governments and school districts. While the state maintains significant powers to set the curriculum and other educational matters of its schooling system, a large portion of this responsibility, as well as the daily operation of public school systems, are delegated to local authorities. These powers are used in ways that benefit or harm gays and lesbians. The school district can decide to establish schools for gay and lesbian students, such as the Harvey Milk School in New York. They can encourage or discourage gay-straight alliances, and they can design programs and policies to protect gay youth from harassment and bullying in the school. They can also include favorable references to gays and lesbians in their curriculum or refrain from doing so. Although the state can act in many of these areas in ways that preempt and overrule local actions, they often don't do so, leaving the de facto power at the hands of local authorities. And the last thing I want to discuss, although we could have discussed more, is districting. So given the various powers of local governments and their ability to influence the lives of gays and lesbians, political representation in municipal bodies is of immense significance for gay rights advocates as well as their opponents. Perhaps most telling is the fact that while Texas, North Carolina, and Florida have constitutional or legislative ban on same-sex marriage and have no anti-discrimination laws protecting gays and lesbians, cities like Houston, Texas, Franklinton, North Carolina, and Key West, Florida, have elected openly gay mayors. The prevalence of the district-based electoral system and the way in which the electoral districts are drawn are probably the core reason for the dilution of gay and lesbian voters. It is rare, if at all possible, that gays and lesbians form majorities that are large enough to win over federal and state voting districts. No matter how district lines are drawn, their sheer size and the fact that gays and lesbians are a small minority prevent them from forming district-wide majorities. Now, the Voting Rights Act, which was designed to address the issue, the Voting Rights Act that was designed to address the issue of minority vote dilution does not improve gay and lesbian chronic minority status because the act, which is interpreted by the Supreme Court in Jingles, that provides special protection to designated minority group do not apply to gays and lesbians. So, in local governments, on the other hand, gays and lesbians can more easily form district majorities. There are several scenarios in which this could happen. First, in the extraordinary cases where gay and lesbians form a citywide majority, which can happen only in very small towns, no matter how district lines are drawn, gays and lesbians will be able to elect representatives. Now second, if gays and lesbians are concentrated in a neighborhood, which is an electoral district, for both historical reasons or due to the goodwill of city election board, again, they will have the power to elect their own representatives. A third possibility is when the city charter enables or even mandates the creation of gay electoral districts. Now, the New York City Charter exemplifies this option. What we see here is the language of the New York City Charter as amended in 1989. And we can see that it says that this plan should keep intact neighborhoods and communities which establish ties of common interest and association, whether historical, racial, economic, ethnic, religious, or other. Now, according to some commentators, the term other was in fact a subtle reference to sexual orientation, and it was indeed interpreted as such by New York's Districting Commission, New York City's Districting Commission, which created a gay district in Manhattan. Now, gearing towards the nationwide redistricting process following the 2010 census, the question of gay electoral districts and the problem of the underrepresentation of gays and lesbians have become pivotal in many cities. And gay mentoring, which is a term coined to describe the manipulation of district line drawing in order to increase or decrease gay and lesbian representation, is hotly debated and received the attention of media and voters across the nation. Sacramento, for example, the gay and lesbian community is concentrated in an area called the Grid. This area, however, is currently divided into 3 separate electoral districts, significantly diluting gay and lesbian representation in City Hall, since they do not form majority in any of these districts. Currently, there is a debate concerning the Castro in San Francisco, as gay activists argue that the redistricting that takes place now threatens again to dilute a gay vote. So we've seen several areas in which local governments can affect the lives of gay and lesbian in significant manner. And now I want to move to a discussion of residential patterns of gays and lesbians, and then connect the dots. So over the past 50 years, residential patterns of gay and lesbian throughout the nation have significantly changed. While New York City, LA, San Francisco, and Chicago are still among the 10 most gay-populated cities, other localities, often medium-sized cities such as San Antonio, and Santa Fe, have taken their place as the fastest growing in gay population. Over 40 metropolitan areas in the United States now have a sizable gay community, and gay and lesbian, especially those with kids, are moving to the suburbs. But, as I said at the opening of my talk, despite these changes, one thing remains the same. Gays are still concentrated predominantly in large urban areas. In fact, the concentration of same-sex couples has remained consistent throughout the years. We have some examples here. First, see the concentration of gays and lesbians in states such as California, Massachusetts, Florida, and Texas. Okay? And within these cities, what we see that gays and lesbians tend to be highly concentrated in a small number of neighborhoods. Again, there are some examples here. This is Atlanta, Georgia. Okay. Previous census, actually. This is Houston, Texas, Nashville, and San Francisco that most people are familiar with, the Castro, etc. Now, the concentration of gays and lesbians within specific cities and neighborhoods is in all likelihood much higher than the census data suggests, because the census collects data only about same-sex couples. The single gays and lesbians are completely missing from the data collected in the census. And since non-partners gays and lesbians tend to congregate in urban areas even more so than same-sex couples, it is fair to conclude that the rates of concentration of all gay and lesbians are much higher than the census-based studies find, and there are no studies that collect data or that manage to collect data about non-partners gays and lesbians. Now, these unique residential patterns begs for an explanation. Why the concentration, and why in cities? Why in certain cities? After all, gay and lesbians are not born only in cities, and are not born only to gays. They migrate into cities, and the puzzling thing is that they keep doing so. Unlike racial and ethnic minorities, whose continued segregation is often explained by the structural difficulty of escaping the places in which they are born, the opposite is true for gays and lesbians, who seem to persistently move into and concentrate in a limited number of locations. So if you look at the contemporary literature, you find two explanations for the residential patterns of gay and lesbians. One is the social quest for community, and the other is the search for better local amenities. So, social explanation describe the process of the formation and maintenance of gay neighborhoods as resulting from a need for a defined space in which community can be formed and in which the unique and alternative lifestyle of gay and lesbian can be institutionalized. The economic explanation for gay and lesbian residential patterns focus on market forces and economic incentives that impact and constrain choices made by individuals. Cities that offer high and adult-related amenities are especially attractive for gays since they have a larger disposable income due to the fact that they have fewer children on average. The concentration of many amenities in large cities attract gays and lesbians into them. Now, these social and economic explanations are correct. I'm not saying that these are not true. But what you see there, that sociological and economic explanations emphasize extra legal reasons for the existing gay and lesbian residential patterns. In fact, some of these studies expressly deny the influence of legal rules on residential choices made by gays and lesbians. These studies look at the laws of the state in which gay and lesbian reside, and pointing to the fact, which I highlighted at the beginning of my discussion, that there is no correlation between pro-gay states and the presence of a sizable community, a gay community in them. We, on the other hand, argue that the law is crucial for the understanding of gay and lesbian residential patterns. What happened is that the former studies just looked in the wrong place. In light of the central role cities play in regulating sexuality, local laws and regulation constrain the choices of gays and lesbians by giving them tangible and symbolic incentives, both positive and negative, regarding which cities and which neighborhood they should live in. While some issues are easily understood to be as a result of legal principles, such as local discrimination ordinances and the same-sex partnership registries that I mentioned earlier, others, such as local amenities and a vibrant community, are mistakenly thought to be extra or pre-legal, despite the fact we're against hostile environment. Despite the fact that they result from a city's application of its zoning, business licensing, districting, and other police powers. This confusion led some scholars to mistakenly conclude that the legal environment is immaterial for gay and lesbian residential patterns, when in fact, the parameter with the empirical studies find as positively correlated with gays and lesbians residential patterns, such as high amenities, such as diversity, urbanization, are themselves a consequence of the legal powers which cities possess and apply. The correlation between local legal decision-making and residential patterns is accentuated in conservative states. This is the place where we can actually prove our argument. Such states often have a significant gay and lesbian population that concentrate in large and medium-sized cities. And while these states do not recognize or even ban same-sex marriage and have no sexual orientation anti-discrimination law, the cities in them where gays and lesbians concentrate have enacted local anti-discrimination laws and adopted many other pro-gay policies that I discussed earlier, and example abound. These are some of the cities, some of them are really important cities that you can see: Atlanta, Nashville, Austin, Dallas, Houston, Astor, Boulder, Denver, etc. In fact, almost all states have cities with pro-gay local ordinances and policies, and these cities are where gays and lesbians reside in relatively large numbers. But the law, as Lawrence taught us many years ago, does not merely impact residential patterns of gay and lesbians, it is also a product of these patterns. So individuals and groups try to influence local lawmakers and policymakers to enact and enforce laws that will advance and preserve their interests, lifestyle, culture, and normative vision. This is true for gays and lesbians as well. And it's true for the groups that oppose gay rights. The ability of groups to influence the political process depends on numerous factors, like the relative size, the economic power, the political clout, ability to organize, and geographic dispersal. And while there is an ongoing debate regarding the political and economic power of gays and lesbians, here I want to focus on the relative size and the geographic contiguity of a gay and lesbian community as parameters that determine, at least to some extent, their ability to influence the enactment of legal law. The relative size of the group that shares common interests affects its ability to influence the political and legislative processes by electing city officials that would represent its interest in City Hall, as well as exerting pressure on city officials. Hence, the residential patterns of gay and lesbians, namely the concentration in a limited number of cities and within them, within a small number of neighborhoods, enable them to impact lawmaking and policymaking at the local level, much more so than they can do in the state and definitely in the federal level. Indeed, according to a recent study, cities with a large gay and lesbian population were found to be much more likely to adopt anti-discrimination ordinances prohibiting discrimination on the basis of sexual orientation, which is not surprising. Now, so far, I described and explained the legal phenomena of the localization of sexuality and this geographical, social phenomenon of the concentration, territorialization of gays and lesbians in specific areas, residential patterns, and try to explain the connection between them. Hopefully you are convinced. But as I said, despite their enormous importance, the localization of sexuality has taken place with no public deliberation, no comprehensive theoretical analysis, and no overarching guiding principle. And it is time to think critically about these phenomena and evaluate their normative implications. So I would like to do that through three prisms, each having a distinct focal point, the individual level, and the community level, and the societal level. One of the major advantages of the localization of sexuality is that it creates cities of refuge in which individual gays and lesbians can lead their lives free of discrimination, harassment, and fear of violence. However, although these local initiatives indeed provide a significant and invaluable protection to gays and lesbians, the jurisprudential weakness of gays and lesbians, of American cities, and the legal submission to state and federal powers subject them to their decision to a constant threat of being annulled by their state. First, there is a limit to what cities can do, so they cannot marry gays and lesbians. Second, the extent to which they can confer real benefits is potentially and sometimes de facto constrained by the state's constitutional home rule powers. And furthermore, cities' ability to benefit same-sex partners, to protect gays and lesbians, is constrained by specific state legislation that might preempt local action. And due to their limited taxing powers, cities have at their disposal only limited funds to spend of gay-related activities, tolerance program, etc. So if we want to think about the localization, we might want to think about empowering cities in order to enable them to provide to sexual minorities the benefits that, the more powerful benefits in a way that states cannot take them away. But, as I hope I showed before, the city power can prove to be a double-edged sword. As we've seen, while some cities use the discretion to benefit gays and lesbians, other cities use it to express condemnation and disapproval of gays and lesbians. In most cases, they simply abstain from taking any action, but when we look at inaction in a hostile environment, what we see is that gays and lesbians are exposed to discrimination, harassment, and sometimes even violence. So if we want to empower cities, we do have to find a way to protect individuals that are that reside in such cities from the excessive power of local governments. On the community level, the concentration of large numbers of gays and lesbians in geographically contiguous areas and the ensuing legal protection and benefit granted to them are conducive to the formation of vibrant and empowered communities. Where local background legal norms allow, protect, incentivize, and even finance gay and lesbian establishment and association, their communities can thrive and flourish. In these communities, individuals can step out of the privacy of their home, where they are protected by the privacy doctrine of Rossen-Zvi, Texas, into a public sphere which they can shape according to the shared value and cultures. Moreover, in cities where gay and lesbians constitute a locally significant constituency, they might be thought of as exercising self-rule. This point lies at the heart of the compelling argument made by Heather Gerken. Permanent minorities, those that could never become a majority, become the majority of the votes at the federal level, who radically differ from the majority, are thought to be able to do nothing more than to voice their dissent or compromise the radical disagreement. They can speak truth to power, but they can never be powerful. And if they want to act, they need to modify and de-radicalize their views and positions. But in fact, Gerken argues, the American structure of government enables such minorities to dissent by deciding, thus act radically and speak truth with power. Such permanent minorities can do so since they are able to form local majorities which the law grants with decision-making powers. A good example of that is San Francisco's mayor's decision to marry same-sex couples in defiance of California's refusal to recognize same-sex marriage. Although it was clear that the city's position on gay marriage was minority views in both California and the Federation, by extending their authority to issue marriage licenses to same-sex couples, San Franciscans did more than voice their dissent, they acted upon it. The strength of dissenting by deciding lies not solely with the immediate benefits and consequences to gays and lesbians who were able to marry in San Francisco, very few. The decision of the mayor was very quickly halted by the courts and later declared beyond his authority. What's more crucial is that through such local disobedience, minorities are able to give their dissenting viewpoint, salience on the national plane. When San Francisco began marrying same-sex couples, gay marriage entered every living room in America as a concrete practice, not just an abstract issue. The nationwide ripple effects caused by such governmental action were also felt at the local level as other communities with similar views followed suit. So there were other places that were rebelling against their states marrying same-sex couples for a few minutes. But there is a danger to this territorially based community empowerment. The risk is that it will result in more social friction and strife. One of the major reasons for this is that gays and lesbians find themselves in competition with other minority groups, in particular blacks and Latinos, over the allocation of resources and recognition. As various studies have shown, city politics is often characterized by pitting minorities against each other, causing intergroup conflict and rivalry. Implied in this process is the accentuation of identity politics and of the radical differences between social groups, which might result in strengthening of stereotypes and animosity. The last thing, the societal level, one of the greatest advantages of the decentralization of decision-making power to localities, as regards sexual minorities in particular, is the pluralism that it fosters. That every local government can, at least to a certain extent, decide on the extent to which it favors or disfavors the interests of gays and lesbians, ensure that the plurality of views about the proper role of government in the regulation of sexuality exists. In Madisonian terms, the localization of sexuality promises that no one view about such matters gain complete dominance throughout the entire federation. That pluralism becomes a safeguard against state-sanctioned inequality. Pluralism as equal. Indeed, cities were the first to break with the hegemony of heterosexuality, enabling the emergence of a more pluralistic vision of sexuality. Already in the 70s, when not even a single state had anti-discrimination laws prohibiting discrimination on the basis of sexual orientation, 16 cities enacted such local ordinances. In the following decade, 24 cities and counties added sexual orientation to their anti-discrimination codes, while only 2 states followed these cities' footsteps and did the same. These cities were spearheading this process, it should be noted, were not necessarily located, the cities that were spearheading were not necessarily located in liberal states. In fact, some of them lie in the heartland of the most conservative ones. Thus, while Texas was still enforcing sodomy laws in 2003 for Lawrenceville, Texas, Austin had enacted its anti-discrimination ordinances already in the mid-70s. And today, cities are still at the forefront of the pro-gay legal innovations, even though national politics rather dominantly endorses heterosexuality as the preferred sexual orientation. The pluralism guaranteed by the localization of sexuality is not confined to pluralism as equality. Since localities can use their power to express the disapproval of gays and lesbians, the range of attitudes towards homosexuality and heterosexuality is broad, reflecting the real plurality that exists among the American people. Since towns and cities are important political institutions that are directly responsible for shaping the contours of ordinary civic life in a free society, it could be argued that cities that express condemnation of homosexuality are too expressing local constitutionalism. And even if we disagree with their particular view, it demonstrates the profound diversity that vibrant localism fosters. But where there's hope, there lies danger. Local innovation and community self-expression might deteriorate into a full-fledged balkanization and fragmentation of the body politic. Lacking legal and political constraints, localities might express and enact into law the most radical and violent views, often targeting weak and vulnerable minorities. And instead of Madison's positive pluralism, we might in fact face what he termed the violence of faction. Indeed, Madison was mostly concerned with the risk that the Federation would deteriorate into a multitude of radical religious factions combating each other with ever-increasing zeal. In his view, a structure of weak federal institutions, overly strong states and localities, could bring about the deprivation of individual rights within states and localities and the radicalization of the entire federation. Madison's cure, extending the sphere, will potentially de-radicalize the local zeal and result in a moderation of extreme politics in light of the large number of people with opposing views throughout the federation that would balance each other and the restraining effect of federal leads. The debate among local government scholars concerning San Francisco's decision to marry same-sex couples exemplifies the tension between the advantages of localism and its dangers. In contrast to the optimism of localism, such as Professor Richard Strager, who celebrated the constitutional role that cities can and should play in the issue of marriage, Richard Ford was much more pessimistic. So while Strager finds merit in the delegating to localities the power to decide who can marry, who actually was calling on a recognition of the power of cities to marry same-sex couples, Ford was worried about the type of constitutional, quote, the type of constitutional revelations we might expect in other cities with different political constituency. In other words, the risk is that city will adopt radical measures concerning gays and lesbians in opposition to the more moderate federal ones, and that this radicalization will create an extremist feedback. Whereas some cities legalize same-sex couples, other cities might respond aggressively to some legal successes of gays and lesbians by adopting explicit anti-gay policies. So sexuality is a matter of geography. It changes across states and cities and between the private and the public spheres. Sexuality is also a matter of law. Legal rules draw boundaries which define, demarcate, constrain, and limit the contour of sexuality. Our ability to act upon it and to form communities on its basis. This rule plays a significant role in shaping individual and collective choices regarding where they reside and where to stay away from. The residential patterns of gay and lesbians are thus partly a result and partly a cause of these legal rules. These processes that, as I said, have taken place with no public discussion are so important that they have to be discussed and has to be negotiated. So far, courts and legislatures have merely responded to urgent and pressing needs, but gave no in-depth thought to the overarching legal structure that came to be. Therefore, imperative to reconsider the current legal structure and doctrine concerning sexuality. Thank you. Now, if you have questions, I will be happy to answer.
Well, first you said 4 states have same-sex marriage. I was just wondering how many had same-sex marriage or
Civil unions?
reasonably equal rights civil unions.
Okay.
Just because it's one of the intermediate lines.
Right. So what we have here is also, these are the different kinds of colors show you the different kind of, so what you have, these are the ones that have the civil unions. These are the ones that recognize it. This is not completely true now because you have Washington State too. But these are the states that actually recognize same-sex marriage. These are the states that prohibit it completely, and these are the states that have civil unions. So now you have the map more or less. You have all sorts of other, yes.
I was hoping you can talk about a specific city in terms of, I guess, the issues that you pointed out have an effect on gay lifestyles within the city. And you spoke about zoning and that kind of regulation and anti-discrimination laws for like housing and things of that nature. Houston is usually described as a city with the least amount of like zoning and that kind of regulation, but you had it listed in one of the top 10 cities.
Yeah.
So I'm kind of curious as to what kind of laws Houston has in terms of regulation and anti-discrimination laws and how that affects gay population or not.
So the thing is that you can, some of the stuff that I've described is easily is lent to empirical research. So you can actually check whether local anti-discrimination laws correspond to the cities where gay and lesbian reside. And we did that, and it corresponds. And same-sex registries, again, it's very easy to find whether the city has a same-sex registry or not, and you can correlate it to the gays and lesbian residential functions. The zoning and land use laws are much more complex in this way, because there are many types of zoning laws. And as I said, Houston is an example where you can't necessarily find a specific zoning because of Erickson's utopia, where zoning is actually much strong, if you say, if any. So all I can do here is give anecdotal examples that I can find, but we did not do that systematically, and I think it's very hard to actually do that. But it would be interesting to actually try to look for cities that have anti-discrimination laws and registries, and to look into the actual zoning and land use practices that they have there, and to see whether it corresponds or not. We didn't do this work.
You said you did do correlated to anti-discrimination laws, right?
Yes.
Does Houston have any kind of anti-discrimination laws?
Yes, definitely.
Regarding your last comments, I can imagine that there are some issues where having local diversity of regulations is kind of reasonable. But like same-sex marriage is something that like is the same problem everywhere. So how is it possible to justify this local diversity in terms of addressing these
What Schrager says?
yeah,
Schrager argues that even I actually don't agree with him, but he says that even the issue of marriage is something that is local in the terms that the community itself has a stake in it, and that's why we actually don't need, we have to decentralize it to the local level, let each community decide whether they want to recognize same-sex marriage, don't want to recognize same-sex marriage, and it will be a good thing. Plurality, the benefits of localism, etc. But of course there are.
what's your view on? Do you have any normative claim in that?
Well, in the paper itself, we are trying to offer a way to both empower cities and to somehow protect gay and lesbian from the excessive power of two abusive cities. I don't know that we managed to do that, really. This is the part where all the people, no, not all the people, but most of the people that read it, including the distinguished Professor Friedman, was not convinced, right? Right. If you say so. And I think this is when it's easy. It's when you do the empirical work, when you do you explain it, when you see the normative issues that are on the table, that's complex but manageable. When you're trying to actually decide whether you want more localism or want more federalism, it really depends on your point of view. So I am more localist than most people, I guess. Same-sex marriage is not a good example, but if you really want, so I did not present it, but there is another. There is another part for the paper. It's called federalized localism, as I said, and it tries to do something to kind of compromise the power of the cities while creating institutional mechanisms to check the potential abuse of power. But to answer your question, actually, this is what I want to say. What we find in our system is an attempt all the time to find the level of government that will handle a specific issue. So we say immigration, federal level. Marriage, federal level. But if you talk about zoning, it could go to the local level. Whereas in fact, while in fact, the truth of the matter is that all of the issues, immigration, marriage, zoning, have both local aspect to them, regional aspect, and sometimes even a federal aspect to them. So what we might think of doing is actually think about multi-level governance of sexuality and multi-level governance of many other things. So what we can do here is somehow think about specific issues that can be done by local governments and other issues that will be governed by different levels of government. And in fact, when you look at what actually happened, the fact that only states can marry, okay, which you could think about a system in which only the federal government could decide on marriage, because then it will, solve all the problem of interrelation between states themselves. The same-sex partnership registries are actually a way to show, yes, but we want to recognize this partnership in some way. And it's kind of a beginning of thinking about multi-level governance of sexuality. So it might be a good idea. Just what happened can become actually what should happen. This is necessity becoming into virtue.
I'm curious about two things. One, in the area where cities decide to create some form of gay marriage when the state does not allow it. I know one of the debates.
When, again?
When the cities offer marriage, same-sex marriage, when the state does not allow same-sex marriage. I'm curious how what those marriages, how they hold up across borders, especially in light of the conflict over whether or not a marriage from one state to the next
You're
will be
talking
recognized
about,
and respected.
it does not exist, so you're talking about if it exists in the future.
I'm asking what the relationship or the analysis is at all.
What's the
I don't
relationship
know.
between states? So you recognize, you have one state that recognizes, another state that don't recognize. What you do, you have
Some
the
states
problem
recognize.
of boundaries here too. So people like Schrager saying, okay, it's not so bad, we can deal with it. Like we deal with, interstate marriage, like the fact that you have one state that recognizes same-sex marriage and another don't.
And the second question was going to be, what are the supposed benefits? Are there, what's the supposed purpose of the same-sex marriage at the local level? Is there anything tied up in property rights like inheritances and custody and splitting property when people separate, or is it mostly about social recognition?
You're very specific about the same-sex marriage, and you're asking about if we decide to do that, what would happen?
No,
You
I'm
have
asking
same-sex registry.
You said, yeah,
And
my-
About
Other areas.
registries, you mean?
yeah. What have the benefits of them
exists.
been? That's what
Oh,
I
no,
meant.
the same-sex registries, there are two kinds of registries. One that enumerate the benefits that the registry gives. Okay, so if you have, you're registered, your partner gets health insurance, for
Okay.
instance, or other benefits. Another way is that the registry is only symbolic on some level, but then public and private actors can actually use this registry and say, oh, here's the registry, we can know that this is your partner, and now we give all the benefits that, so you may have cases in which some private actors would use the registries and others don't
Okay.
use it.
So if I'm registered in one city,
Other cities don't.
and I move to another city which has same-sex registries.
You have to
Would
re-register.
Hmm?
You have to re-register.
Oh, so it's
Yeah.
not like same-sex marriage between states which both have it? Because I would think they would honor each other's marriage.
Yeah, but it's a different system. It's not transferable from one state to another. At
They
least I
could
don't know.
do that
Of
if they
course they
felt
could.
like it, but
They
it's
just
not the
don't.
way they do it.
Yeah,
Oh,
just
okay.
don't do it.
So it's
They could do it, yeah, but every registry is different. Because it's local initiatives, it's kind of grassroots.
Well, I wouldn't get the same rights
Yeah, I
in
understand.
another state, in another city.
You mean
But
so,
I was assuming
as a matter
that
of convenience?
when I was same-sex registered in one city, that other cities would honor that
Mhm.
stamp. That have the registry of theirs. They don't have that? Thank you.
It's not working like that today.
Okay.
It could, but it's not.
Just to study both the effect of a growing community and the effect of regulation, which could both explain development, have you been able to relate also to historical data? And maybe when, for example, a particular measure was put into place and relate these events to particular growth, and the distinction between the two.
No, and the reason is that census data that collects information about same-sex couples started only in the 90s, late 90s. I think 1990 was the first one, 2000 was the second one, and now 2010 was the third one. Before that, no census data was collected, nobody knows, some people try to figure out from, but no reliable data that you can actually say this is the number of same-sex couples. So without the data, you can actually do nothing. What you can see is the legal regulation in these places that you can track. But since you cannot do what we try to do is, to correlate the two things, so before that it's impossible to do. Yeah.
So, a follow-up question to my previous comment. So, I think that there are two stories that you're offering. So, the first one is like, so the localities are reacting to the lack of a federal and state definition on same-sex marriage. That's the first step. The second version would be, there is a role that localities have to play on do you defend both?
I didn't understand the second one.
The second one is, well, in the definition of same-sex marriage, there's a role that localities have to play. It's not only like a federal or a state level, it's also there's something that should be decided by localities. So
They have.
that's what I understand from your analysis. If you're also defending this second.
I'll try to describe what you're saying and respond, in a way. So, what enabled cities to do that was the fact that no federal and state legislation impedes them from so doing. Okay, so what you find is that in other issues, for example, the federal laws would have, protected gays and lesbians from discrimination. So local government would have, no power of doing anything. If federal government decided that same-sex marriage is recognized across the federation, local government would have nothing to do with it. So what you have is decentralization, unintentional in a way, but happened because of lack of regulation of this issue on higher levels of the government. When you go to the local level itself, with some things they have to deal. So you have a bar, that someone applied for a permit for a gay bar in a certain place. They can actually, they have to say yes or no. So this is something that they must do. So they react to reality. And they can say, no, we don't want these people here, so we zone them out or restrict their businesses or use public health in order to exclude them, etc. In other things, there could be inaction. So with discrimination, for instance, the locality could say, I'm just not doing anything. I do not regulate, I do not have ordinance that includes sexual orientation as the basis for protection. And then, again, this omission is actually an action because it leaves the gay and lesbian population exposed to private discrimination. So again, it's a different kind of action, but it's action by omission. Sometimes they don't think about it because there is no gay population, because it's not vocal enough, etc. But this is so. If I understood you correctly, this is the connection between the two that you mentioned.
We've reached the hour. Thank you. That was terrific. Thank you very much.